case of Adomako Anani versus Nana Owusu Ajimang. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April, 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the Court of Last Appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you were part of the case. Today we're still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case. But I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes,
I mean, the
the
court was happy that they had finally resolved the matter. It was basically a land matter. But what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court, that's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3,
Yes.
attempts to get justice?
Yes.
And if at the 3rd attempt you are not satisfied, you just have to live with that and rather work on the quality of the courts so that, by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that would be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level,
absolutely,
which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking? In view of the discussions going on about amending and reviewing our Constitution.
The Honorable Chair, this is a very interesting trajectory that this question is taking. People, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 plus 9, that is 10, as our Constitution provides, and not go up, is dependent upon the jurisdiction of the court, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where civil cases or whatever, can go all the way to their Supreme Courts. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there is a criminal case, Ali Kasina, started in my village at Goso, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution, that a person has a right to go all the way to the Supreme Court, people are prepared to, and now, see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. That if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You find that about 35 of that number of years happened in the trial court. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that, no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where proceedings were supposed to be adopted, you'll find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, that one alone is enough. But as I said earlier, there must be a way of tracking cases, so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to ask it to arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement, the writ, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay, for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett-Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2. It's just a view. My Lordship, Paul Baffoe-Bonnie, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree, I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training, we are doing substandard work that the products are substandard. But that is not the case. We are also not overproducing, actually. You see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together, from 18th century, Mensa Saba and all that, we're not up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. A lot of them have migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even in practice. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, the law is such that the district assembly law, the local government act, expects every local government to have a legal department. And when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than 1 person. Every local assembly, House of Chiefs, all the houses of chiefs, So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or ply their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the ones, the number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. They just, the headmaster of my school, the best secondary school in Ghana, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which he will be doing at the end of November, then when he retires, then he will pick his law, he'll go and do galamsey. No, not the galamsey. The lawyers understand legal galamsey.
Are you talking about galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So, my honorable chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further questions?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, if I I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the the Constitution of America, of the U.S. That is, they are what we call a constitutional court. But Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We will not be able to work at all. The only thing that we have to, there are 2 things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court, by an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at the high court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord.
Nothing useful to add.
Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the Honorable nominee. We have Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedu Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family. We have Mary Kwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Amantahini. Anantahini. Forgive me if I don't pronounce it well. Typical Aigbe boy pronouncing three names. Then we have Nana Dr. Abura Boatin, Nyinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have all students of...
Well, so from 11 a.m., it's almost 7 p.m., you could say 8 hours straight, even though there have been some breaks in the middle of for the vetting of the foremost member of the judiciary of Ghana, the Chief Justice, Justice Paul Baffoe-Bonnie. He has gone through the vetting process at the Appointments Committee of Parliament, and that's the concluding part that you've just heard there. He's been asked all the questions that have to be asked, even though it's just from the NDC side. The minority NPP side staged a walkout earlier in the day. Gentlemen, let's wrap up. Let's just take a quick comments, your key highlights before we leave. Mine, of course, would be where he said that we don't have enough lawyers, we should train more lawyers. That for me is exciting. So it means that, and he even talks about expanding the law school so that many more students would be admitted. And I always make this point that, why do people say we have too many lawyers? why don't we say we have too many teachers or too many doctors, especially when lawyers pay their own school fees to go to school? Let the person go. He has his money. He wants to go to school. Let him write the exams. If he fails, he fails. If he passes, he passes. But this issue about too many lawyers, I don't understand. So, my Lord Justice Baffoe-Bonnie, you are doing my job. Sorry, you don't understand. You say me that as in your point. Fred, your takeaway.
Very controversial beginning of this particular vetting, leading to the minority working out, but then a very good vetting process.
Despite the one-sidedness?
Despite the one-sidedness. At this point, you're expecting that maybe the members of the majority side would have just let the Chief Justice go just like that by asking one or two questions, but very deep questions about how to improve the judiciary, questions about the number of Supreme Court justices on the court now and whether there were too many, and the fact that he believes that they are either going to expand it to about 2025 or get the Constitutional Review Committee to really look at the Constitution to reduce the jurisdiction of the Supreme Court. And also, one of the things I was looking for him to answer is the concerns about the minority. One of the reasons why they walked out.
Which he did,
about the ongoing cases filed by the removed Chief Justice, Gertrude Tokonu, and whether the Parliament should have gone ahead with this particular vetting. It was his view that he doesn't believe that this vetting should have been stopped